It feels funny to welcome you to a panel, which is called the All-Out Assault on Agency Authority, but that's where we are. I'm going to begin by introducing the panelists and then give a brief kind of setup here. I couldn't be more excited to have these panelists on this question. They've all been thinking about it intensively and at different levels for a long time. So immediately to my left, Lisa Heiserling is literally the Justice Brennan Professor of Law at Georgetown Law School. She is widely known for her influential work on cost-benefit analysis, critiquing presidential powers, and judicial review of agency action. She's had influential work as an academic, to be sure, leading work there. She's also been engaged in litigation and policy. In the Obama administration, she was senior climate policy counsel to the administrator of the Environmental Protection Agency, and also served as associate administrator of EPA's Office of Policy, and she played a leading role in the briefs in Mass versus EPA. Sam Sankar is Earth Justice's Senior Vice President for Programs. He's devoted his career to environmental law, litigation, and policy, and he's been involved in every facet of the field, arguing cases under virtually every environmental statute, and also serving on the Presidential Commission investigating the Deepwater Horizon spill. In his current role, he leads Earth Justice's efforts on oversight of their impactful litigation and policy and legislative work. Finally, Allison Zeev is the Director and General Counsel of the Public Citizen Litigation Group, and she also serves as its Director of Supreme Court Assistance Project. In that role, she's been a longtime leader on issues of public health, consumer safety, open government, and much more. She's argued 5 cases in the Supreme Court and multiple cases in the Court of Appeals. Of particular relevance here, she has also judged the American Constitution Society's Cudahy writing competition since its inception. So thank you so much for that long service there. So that's a wonderful group of panelists. And now let me just kind of set the stage a little bit, which is, of course, agency authority, as this group well appreciates, protects the public and has the capacity to protect the public in so many ways, right? It protects us as consumers, as workers, engaged in the financial system, our engagement with the healthcare system, and of course it also protects our air and water, right? Today, agencies' power to execute on their mission is threatened by an emerging set of doctrines instigated in the Supreme Court that are unsettling established administrative law and separation of powers. And those doctrines in particular, I think most of us have heard of the challenge to the Chevron doctrine, right, in the Loper-Bright case, but there's much more. I think of it as sort of the challenge to Chevron plus, and I've got a couple pluses to add here. We have plus the corner post case, which we're going to talk about today, which that's currently pending before the Supreme Court. I know that a public citizen filed a brief here, could interpret the APA's statute of limitations to allow new entities to challenge old regulations. So it's challenge to Chevron plus corner post, which would lengthen or effectively lengthen the statute of limitations, plus the resurgence of the major questions doctrine, in Virginia, West Virginia versus EPA, plus conflicting statements on the rigor of arbitrary and capriciousness review. In addition, there is potential challenge and significant constraints on agencies' authorities to have ALJs in the Jakarski case. So there's a lot of cross currents at issue here. And so my first question really is, are there any particular dynamics or interactions among these doctrines and developments that you think are particularly important and worth our paying attention to? So let me just kick this off with Sam, if that's okay.
Sure. Well, thanks. And thanks, everybody, for coming. So I think it's interesting. You should see up here you have 2 environmental lawyers among the very few environmental lawyers at the conference. And the reason why we're here is because these doctrines are playing out so acutely in administrative law, in environmental law, which is often the set of laws that take it on the chin when courts get interested in administrative law. This is a place where there's lots to chew on and a place where judges are very interested. And I guess what I wanted to say is everybody's talking about Loper Bright these days. In fact, on Thursday, I was sitting there waiting for it to come down. And why, I have a somewhat heretical view about this case, which is that it's not actually that important in terms of its doctrine. Why? Because when you argue, I was a lawyer at the Justice Department for years defending these kinds of regulations, and you never started your brief by saying, under Chevron, you need to defer to the agency, and we win. There's 65 pages of the brief that go on talking about how the statute is crafted to allow this approach, how the approach is really sensible, how it makes the best sense of the statute and its legislative history and everything else. And then maybe the second to last paragraph is, oh, and by the way, I mean, if you really find yourself as that one judge who doesn't know what to do, okay, defer. So when the court says, and when Justice Stevens always said about this doctrine, I thought it was sort of common sense, and I'm surprised that everybody found like it was such a big deal and it got cited all the time. So when the court says we're coming after Chevron, or not in so many words, but when it's clear that they are coming after Chevron, what I'm interested about is what does it mean? What does it signal? Less than I'm interested in how the doctrine plays out in the lower courts, because I think if you say, oh, I can no longer cite Chevron, I don't think your brief is fundamentally different. I think you're doing the same sort of thing that you always did. But what's different here is that the court is sending a signal. I think the court is sending a signal, it's a flare that says, you get your say first, judges. Rather than having to slog through that whole brief that you were supposed to go through, the first thing you can do is think what you would do. And you can read all that stuff if you want, and you can learn it. And if it dissuades you from what you think should be the answer, great. Well, you can be dissuaded. And that's not a flare or a call that is going to be accepted by very many judges. Most judges are going to do this the same way they used to. I think I've talked to many judges who say, I don't really know what I will do all that differently. But there are judges who are going to take this as a signal, as a green light, to say, let's go forward and let's start putting our stamp on what these statutes are and what kinds of regulations they authorize. And that's what I'm worried about. What I'm worried about is that the rightist right wing of the federal judiciary is going to take this as not just a green light, but a starting gun to say, start revisiting stuff. And of course, it's going to be really interesting when you see what happens next. How is that going to interact with some of these other things, and how are people going to use it to take specific regulations down?
Great, thanks so much. Allison, can I get your take on this?
Is this on? Okay. So I mostly agree with Sam, except that in Texas, for example, there's no Chevron already, and 9 out of 10 admin law cases are now filed in Texas. So maybe we're already post Chevron. It is still a big deal in DC, and there are a few statutes that direct the cases specifically to DC. And it seems to me that of all the courts to apply that cared about Chevron, it was DC that applied it the most. But I think the my two biggest concerns about Chevron are, one is that it's not just a signal to judges, what the Supreme Court does, but also if there is no Chevron, it's a signal to the agencies to make them more timid. I think the entities that care most about Chevron are the agencies. It gives them some assurance that their views about the meaning of a statute will prevail or will be respected to some extent. And so I do worry that the agencies will be more timid about doing their jobs. My other concern about Chevron is the case Corner Post. Corner Post is the case where a convenience store that formed in 2021 or something challenged a regulation that was issued by the Fed in 2010. The statute of limitations under the APA, 6 years. It's not actually in the APA, it's in a catch-all statute for suing the government, but because the APA authorizes judicial review without specifying the statute of limitations, it's this provision of 28 USC that applies. Everyone always assumed that it was 6 years from when the agency issued a rule. The circuits all agreed on that, those that had ruled on it. A conflict developed a couple years ago. The Eighth Circuit actually has the majority rule, but the Supreme Court took the case whether this convenience store should be able to challenge a rule because it didn't exist in 2010 to 2016, so it wasn't around in the 6 years when everyone agrees the statute hadn't run. My sense from oral argument is that the government is going to lose this case, which means there'll be effectively no statute of limitations at all for challenging final agency action, because there is always another new entity. There's always another convenience store that opens. If a doctor's now, as may or may not happen with the mifepristone case, if doctors can now sue because they don't like approved medicines being on the market, there's always another new doctor. My daughter just graduated from medical school. So no regulation would be final. And so the combination of there's no longer any deference and there's no longer any statute of limitations, I think would just be sort of devastating for stability for agencies, and then the bottom line is for the public, because all public health, safety, environmental, financial protections will be sort of up for grabs, and they're all going to be challenged in Texas.
Lisa?
So I want to talk about the interactions among some of the cases in front of the court this term, and then the interactions with some prior decisions. And as we're on the verge of getting some of these decisions, I think it's worth trying to think about how they work together. So this term, obviously, as we've heard, we have limits on agencies' interpretive power in front of the court, and we also have a case, Jarkissi, about the removal power, in addition to the question about administrative law judges. And I think it's worth thinking about how do those cases relate to each other. So they take place in the context of a situation in which the Supreme Court has already made it more difficult for agencies to interpret the statutes the way they want to. So it's issued a number of clear statement principles forbidding Congress from authorizing an agency to act in certain situations when the question they would have to answer is a question of great political and economic significance. And then also, this is the Sackett case, the Sackett versus EPA case, if it would interfere greatly with private property or the balance of power between the federal government and the states. So you're, against that background, it seems to me interesting to just think about what this does about the power of the various branches of government. So the statutory cases shrink the power of the administrative agencies, right? And of the president, therefore, because the president, as you may have noticed, operates a lot through the administrative agencies. The removal cases, the cases about the president being able to remove everybody in the government, basically, that's the theory, almost all the way down. Those cases expand the power of the president. Isn't that interesting? You take these two different sets of cases and you say, well, that's interesting. The vaunted unitary executive, right, is being cut back in a series of them and enlarged in the other. What could be going on there? Right? What could be going on there? One way to describe the cases is that the president can fire people, but he can't make them do anything important. Right? So this vaunted unitary executive that we've been waiting for it to come and arrive in full for a very long time turns out to be both imperial and feckless. Right? Now, why would that be? Why would that be? Think about it. I think there's an ideological reason, perhaps, and an institutional reason. The ideological reason is this isn't so much about the exact structure of government. This is more about the power of the federal government to take on big problems, or any problems, possibly, right? The institutional thing is, notice who's made more powerful after each of these decisions. It's the Supreme Court. Right? Congress and the executive are both weakened. Second, if I may, I want to also talk about the interaction between the Chevron issue and the clear statement principles I mentioned. So you know about the major questions doctrine, right? Anyone raise your hand if you don't know. Don't raise your hand. Congress can't authorize an agency to address a problem of great significance without speaking clearly. And So the major questions doctrine was originally thought of, or at least in its middle life, was thought of as an exception to Chevron deference. So if it had stayed that way, we might be in a situation where it would kind of go away, right? It would go away. If Chevron went away, then exceptions to Chevron don't make a lot of sense, except that the Supreme Court has now elevated it to a freestanding principle of interpretation, along with the Sackett principle having to do with property and federalism, and has made them freestanding quite apart from Chevron. What does that mean? They're here to stay. Even if Chevron goes, the major questions doctrine and this new principle from Sackett, I think, remain. And so if, as I believe it will, the Supreme Court replaces Chevron with a requirement that the courts determine the best reading of the statutes by their own lights, on their own, if that's what the court does in the Chevron cases, then even the best reading, what might have been the best reading, will give way if the issues are important enough, or if the issues affect private property and federalism too much. So that we're in for a very different world. I actually think it's a very different world, that where the agency now has a couple of different ways to lose, not ways to win, a couple of different ways to lose. And they can lose under the major questions doctrine, or they can lose under the whatever principle of statutory interpretation the court enunciates. And what does this mean? Just a couple of things. One, ambiguity is no longer their friend, period, the end. It has been the agency's friend for a long time. It's not anymore. That is a very large change. Second, courts will have an easy way and a hard way to rule. The easy way will be to clock the decision and say, that looks big to me. Look at the statute. Doesn't look very clear to me. Done. We're done here, right? Think about it. Chevron itself was a shortcut to a decision in a way, right? That's one of the reasons it's possible why it sort of took off in the courts as much as it did. And so I think we'll have pressure on those clear statement principles and some perhaps enlargement of the domain if Chevron goes away. We'll also continue to have steps. I'm sorry, I'm so tired of the 2 steps of Chevron, right? But that's not reason enough to get rid of it. But by the way, we'll still have 2 steps because we have the major question step and then we have the best interpretation step. So that's it.
Great. So that seems like a great overview of some worrisome dynamics going on between these multiple doctrines. And if you can stand it, I want to dig a little deeper and broader still in explaining what's going on. But believe me, we're going to get positive later. Okay. Okay. So
that wasn't part of the plan.
Well, we'll find opportunities for positivity, or at least humor. Okay. So we've talked a little bit about these administrative law doctrines, and so there's some broader constitutional dynamics at play here, and some other broader dynamics at play here. So I think they're important to kind of bring on screen. We've mentioned a couple of them, Lisa in particular. I don't know, maybe can I turn to you, Allison? I mean, to what extent are you worried about, say, the non-delegation doctrine as a background to this and other kind of constitutional issues in the background here?
So a couple of years ago when we got the major questions doctrine, what Justice Gorsuch was really going for was a non-delegation doctrine. So not just that if Congress wanted to delegate to an agency the authority to address some major issue, whatever that means, it had to speak clearly, but rather that major issues couldn't be delegated at all. And the justices write so many separate opinions now that are not really about lawmaking, but are just telling litigants and big business and attorneys general what issues they should raise in their next case. So although Justice Gorsuch didn't get everything he wanted in West Virginia versus EPA, there is an effort afoot to give it to him. And one prominent example is this case that is pending before the Supreme Court at the petition stage called All States Refractory versus OSHA. And in that case, this company, All States Refractory, I don't know anything about what it does because it doesn't matter, represented by a law firm that does all these cases trying to destroy health and safety regulations, is arguing that OSHA's authority to issue safety standards reasonably necessary to protect workers violates the non-delegation doctrine. They know that their theory actually has already been rejected by the courts all the way up. So the whole idea is just to get back to the Supreme Court so that Justice Gorsuch can convince 4 other justices to adopt a broad non-delegation theory that would be first used to undermine all these worker safety standards, and then, take off from there to look at other statutes and undermine agency authority to do other things as well. This is, in the case of the OSHA safety standards, this statute's existed for decades. So there's a number of standards, and it has not been controversial. So I think that's just one example of why the non-delegation doctrine, which has really not been a thing, might turn out to be one. The other sort of bigger issue that I keep worrying about is there's been a number of cases that are challenging, making various challenges in the context of spending clause litigation, arguing that there's something different about legislation that Congress enacts pursuant to its spending power as opposed to its commerce power. Some of these cases are just about whether the rights under spending clause legislation are actually enforceable by the beneficiaries of the legislation. But the case that is considered and is about abortion from Idaho that challenges the EMTALA statute, which is the statute that says that if you arrive at an emergency room at a hospital and you're in distress, the hospital has to stabilize you before they can transfer you or kick you out, regardless of whether you have insurance. HHS says this means that if a pregnant woman arrives at an emergency room in distress, she is to be stabilized, even if that stabilization requires an abortion. Idaho says no, she only has to be stabilized if she's going to die otherwise. It's actually a clear, it seems to me HHS's view is a clear application of, it's just like should be a non-controversial application of the statute. And the court may not deal with it in spending clause terms. It seems like the court's just happy to say that suddenly state law preempts federal law instead of vice versa. But putting aside the supremacy clause, there's also an argument made in some of the briefs that because the Congress's power under the spending clause is more suspect, less enforceable, less broad, and that the agency's powers to regulate under the spending clause, under statutes enacted pursuant to the spending clause, are lesser. So we've seen it in a couple cases. I don't know if the Supreme Court will address it in the EMTALA case, but it might. But both of those cases are just sort of signals of other challenges to health and safety and environmental protections that are percolating. I'm sorry to be so just negative. Kevin promises there's something better, but I'm not sure it's coming from me.
Sam, do you have a kind of larger constitutional background?
Well,
I don't know.
I think Lisa nailed it, right? What's going on is that we have a court that is, it's not skeptical of federal power, federal regulatory power. It is actively against the idea of federal regulatory power. So when these first Chevron cases started coming up, we actually, there was a discussion. It was a short discussion inside of Earth Justice. There's 210 lawyers at Earth Justice who litigate, and about 105 of them hate Chevron. It's the 105 of them that work for agencies that are fully captured by industries. So if you're litigating against the Forest Service, you hate Chevron because that agency is using the deference almost always against the interests of people, the planet, health, safety, all of those things. If you work with EPA, you at least are more optimistic about what EPA's take is on this. There are certainly pieces of EPA that we can talk about that are more or less captured, but you want the agency to have power. You want the agency to have authority. So why, remember Chevron, the other side of Chevron was NRDC. That case was very much a case where the environmental folks did not want EPA to have the discretion that it used. This decision comes out. Remember, I can't say this often enough, that case was a loss for the environmental groups. So why are we so worried about the court overturning it? Because the court is going to use it for bad. And one of my tests on this is I say, would you be worried about Loper Bright if you had the Warren court sitting up there? No, you wouldn't be. Because you know that this court wouldn't be doing problematic things. You know it wouldn't be a one-way ratchet. It would be something approximating a neutral thing. But what's actually happening is that we have a court that is that is actively interested in pulling down the government. And the most terrifying part for me, the good stuff is going to come later, right? One of there's all this other stuff going on, but then when you read in the back half of the Sackett opinion, the Clean Water Act case involving the question about what the phrase waters of the United States means, that where several justices write about how they are not sure at all whether Congress has the ability to regulate water bodies that don't cross states or water bodies that aren't actually being used for commerce. And that's when I'll remind everybody in this room that the original Commerce Clause fights were about Civil Rights Act and the idea of what is commerce. How do we regulate wheat with the very early ones? But this isn't just about environmental law. This is about the power of the federal government to make the world a better place. And if you have a narrow understanding of what commerce means and a narrow understanding of what interstate means, then not only is some small, like an isolated population of flycatchers in Hawaii going to be in trouble, because almost certainly those justices would say, how could that possibly be subject to the Commerce Clause under the Endangered Species Act? But it's like everything is potentially fair game if you've got to defend the link to commerce in a court that is not particularly eager to find links. I want to say one more thing about the deep dynamics. I fully agree with Allison that all this is going to make work harder for agencies. And it comes at a time when you need deep expertise, long tenure in these agencies, and you need well-funded agencies in order to craft these things. And we're seeing right now during this incredible blitz of rulemaking that it is exhausting for agencies, even with full presidential support and agendas, to actually make regulations happen inside of a 4-year administration. And with all this stuff, it's just going to be harder for them to regulate.
Thanks so much. And Lisa, I wonder if I could ask in terms of dynamics, whether there's kind of combination of litigation dynamics or the sort of funding atmosphere for groups that you think is important to kind of explaining our current moment.
Yeah. I mean, this is called the all-out assault on the administrative state, so it's worth thinking about. And sometimes there can be a generalized anxiety about it that seems to go, at least in my case, goes beyond the decisions. And so I just thought I'd put together some of the things that I think are happening that make this particularly difficult. Sort of a perfect storm of circumstances. And this is an incomplete list. 1, we have 2 justices at least who were put in place precisely for the purpose of taking on the administrative state. 2, we have the Supreme Court using the shadow docket as almost a regular tool of review of agency action, right? So just skipping over courts. Actually, they pioneered this, really, true fact, little known by many people, with the Clean Power Plan, which is Obama's signature climate initiative from EPA, right? Just reached out, stayed a rule directly before any court had reviewed it. So that's becoming more and more sort of just a regular feature of administrative law. So the Supreme Court's challenging agency action are nominal plaintiffs in many cases. They don't really have a huge stake in the case. They may feel it fervently, but the real people behind the litigation are billionaires that are funding it. Therefore, I think the individual parties to the case, the commercial fishers we heard so much about at oral argument in Loper Bright, aren't the real parties in interest, really. And this, I think, explains otherwise mysterious developments. And so I'm going to go through a little quick list. The Supreme Court takes the broad and not the narrow path to decisions in a number of cases, or sometimes, weirdly, both. Right? Happened in both the student debt case and in the Sackett case. They said both it's a major question, and let's do the ordinary. Let's just make sure this is really dead, right? So do it twice, right? So, or both. They don't answer the question that is presented, right? They don't dispute dispose of the underlying dispute. That is, they answer a question and then they send it back for the courts to figure out, or for the agency to figure out under unclear law, and without having actually issued a dispositive ruling that disposes of the case in front of them, right? They alter the questions presented. They take the biggest one, that was in Loper, Bright, and Raimondo. They could have just answered what the statute meant, but no, they only wanted to answer the Chevron question. They have taken sometimes to writing the questions presented, right? So in the case involving air pollution and the so-called good neighbor rule from EPA, it's the so-called emergency application that now has been pending for 7 months in the court. It's been 3 months since it was argued. The Supreme Court hasn't still issued its opinion on that emergency. But in that case, the justices themselves said, here's what we want you to address. We have uncontrolled judge shopping, as you may have read about in Texas, uncontrolled by the Supreme Court, which is kind of hilarious, if I can say something parenthetically and kind of funny, like Supreme Court agencies bad, interpreting statutes, issuing guidance documents, there they are, the Chief Justice, the head of the Judicial Conference, issues a guidance document under kind of sketchy statutory authority and says, don't allow judge shopping. And they're like, thank you very much, right? We don't care. So there's a way in which the court was acting sort of as a legislature, or at least an agency in that, and got its head handed to them. So there's uncontrolled judge shopping, and then it's available mostly in Texas. And where do those appeals go? They go to the Fifth Circuit, which has been doing all sorts of interesting things in administrative law, right? So there's a whole set of circumstances that go beyond doctrine that I think explain the fraught moment we're in.
Okay, great. So here we have, administrative law doctrines interacting against background constitutional movement, and a whole bunch of this kind of combination of Supreme Court dynamics and other aspects of our legal system all kind of come together. So let me turn now a little bit and think about, are there strategic opportunities created by these developments that you think that you might be able to use in your litigation practice? That's sort of my core question. I'm also interested about how you think about when and how to embrace these doctrines. So I have other questions too. Maybe are there missed opportunities that led us here, but let's just start with those, which is, to what extent do these new doctrines create strategic opportunities for you in litigation? So maybe Sam, can I start with you, and how do you think about when and how you might embrace any of these developments?
Basically never. That's partially for humor, but here's the reality. At the end of the day, you don't want to end up in the Supreme Court. If you do what I do for a living, there is no circumstance in which being up in front of the Supreme Court, unless you're trying to correct an insane Fifth Circuit decision, like a totally insane, where it just cannot possibly get worse, you don't really want to be there. And so I'm nervous about us trying to get cute with any of these doctrines, because I think at the end of the day, as I said, they're not neutral doctrines. These are doctrines that that do not help when you need their help. They are, at least in the area of law in which I practice, I increasingly think about what is a conservative court. I mean, where my organization practices, nobody lets me get to court anymore. But I think a lot about what is the desire of a Fifth Circuit, any Fifth Circuit panel, or a sort of unlucky draw in some of these other courts. What's it going to do? So I guess I don't think we go shopping for how are we going to use the major questions doctrine. Now that said, I'm not looking forward, if we have one, to a Trump administration. But yes, there are ways in which the most extreme actions by a Trump administration, it's possible that we'd be able to use those doctrines. But I think the judges who are likely to use them for all they're worth are not going to be the ones that we want to be in front of in those particular moments. So Allison litigates in a huge, much broader universe of cases, so she may have more.
Allison?
So I think, well, we could use some of these things affirmatively if the plaintiffs in the mifepristone case have standing to challenge approval of that drug or the regulation, changes to the regulation of that drug in 2016, then every one of us has standing to challenge really anything we want, because standing is not a thing anymore. And standing is something that generally is bad for a consumer advocate, because the Chamber of Commerce always has standing and public citizen only occasionally has standing. And the Supreme Court made that harder and harder, as did the DC Circuit over the years. So in that way, like having standing, always being able to find somebody seems good. In the cases that we bring affirmatively challenging agency action, Chevron's not our friend. Get rid of Chevron. Great. Statute of limitations, there's no statute of limitations. I just need to like find somebody who just turned 18 and they have standing and they couldn't sue yesterday. So their statute of limitations just started to run. We're on day 1 of 6 years. So, great, there's things that, the Bush administration did that I didn't like. Now I can challenge them. But the thing is that all these, the ability to challenge means to get rid of regulation. So 99% of the time, if I bring an action to challenge an agency rule, I want a better rule. So they strike down NHTSA's rule or they strike down FDA's rule, then that means that the agency then has to issue the right rule. But if the agency really doesn't have the ability to do that anymore, either because of lack of support in the White House or because of the combination of all these other doctrines, and if they issue the right thing, it's just going to get challenged by somebody else. I mean, if there's just no end to challenges, then yes, we can also take advantage of it, of all these doctrines, but in the end, we're not advancing our goal of having stronger public protections in place. So I think like as a litigator, could be fun to like have the administrative state totally torn up, but as a like human being, I'm not sure that in the end that actually is going to help anybody. Again, sorry to be negative.
Yeah, I look to the next page. Where are the positive?
Yeah. Lisa, do you think there were some missed opportunities that led us to this moment? If those are
Yeah, and I don't know if they led us to this moment, but I'm just struck at 2 phrases came into my mind as I was thinking about this question, and they're both from Justice Kagan. We're all originalists now, and we're all textualists now. And I'm not just saying this about Justice Kagan. I think for a long time we all pretended we were all originalists now, and we're all textualists. And I don't think that was a good idea, right? Clearly. And I think it's so we don't have a sort of resistance, if you will, to not just particular cases and outcomes, but to a way of thinking about law, to a way of thinking about the Constitution, to the way of thinking about the federal government and statutes and protective legislation and so forth. And so that as long as our case is is okay on the statutory language, that's fine. I did that in litigating cases. I didn't cite the legislative history at all. I thought it was so clever, right? But we've been doing that for a long time, and just letting go of, it seems like, in a lot of domains, and not everyone, but a lot of domains, letting go of these larger sort of fights. You'll remember maybe, probably many of you won't, but the originalism really was nurtured in the Meese Justice Department, right? In the Meese Justice Department in the Reagan administration. And the reason I say that is just that, so that I'm struck on the other hand by, in progressive administrations, the SG's office, I love the SG's office at this time, but it just rolls with the punches. A decision comes out, it goes into the big analysis machine, and that's it. The world has changed, we've moved on. And I just wonder if there's room for resistance. Just some more room for resistance. Meese had every lawyer, to the extent it was relevant, maybe even if it wasn't that relevant, but to the extent it was relevant, make an originalist argument in their briefs, right? I wonder what that would look like if lawyers started a more sort of resistance or new thinking of that kind, even at very high levels. That seems promising to me. And I'll just close with just a reference to Chevron, because that's been so much on our minds today. But that's what happened to Chevron. I've thought about, I haven't written it, but I have an article in my mind called Who Killed Chevron? And the bottom line is, we all did. We all sat there while the Supreme Court first was hostile, and then it stopped talking about it altogether, and then the progressive justices went along with the decisions that didn't mention Chevron. You couldn't say it, and everybody went along with that code. And I just wish it were otherwise, honestly.
Yeah, so you can begin thinking about what the architecture, the legal vocabulary and architecture kind of longer game would be in developing a more contextualist, maybe more purpose-based, and then also not keeping quiet as doctrines are developing and moving here. So let me move a little bit more in a kind of reformist lens of last set of questions, and we'll open it up to audience questions, which is there are a bunch of kind of mid-level reforms out there circulating and floated. So ACS, the Administrative Conference of the United States, I'm a public member. Lisa's been a public member. Allison's a senior member there, is considering a recommendation for Congress to provide direct review of agency rules to the courts of appeals. So direct review to the courts of appeals. There are other proposals revising local rules of district courts so that administrative law cases are filed district-wide as opposed to in particular dockets for particular district judges. There's also proposals for statutory revisions to increase or mandate use of three-judge district court, lower court panels. And I guess my question is, to what extent do you think any of these reforms, or really any other, might make a difference? Obviously not solve the problem, but move the dial incrementally here. So I don't know. I guess I started with Sam last time. So Allison, do you want to start on this one?
I don't think that the proposals to have all challenges to agency regulations go directly to the Court of Appeals serves the purpose of improving the state of administrative law or outcomes or the treatment by the judiciary. It does serve the purpose of speeding things along, since these cases are almost always appealed. And there is some sort of randomness in which statutes say that the challenge should go directly to the Court of Appeals, and which are just, if they don't say it, then by default the case goes to the district court, and it's a little bit random. So I don't have any problem with making it not random and sending them all to the Court of Appeals, I guess, but I'm not sure it really solves any problem. There's also proposals that everything would be a three-judge district court panel, the way like voting rights cases are. I don't think that's actually a good idea. Then they all go direct review to the Supreme Court. I don't know, it just rubs me the wrong way. And occasionally, in an APA case, there is some discovery sometimes, and dealing with that with a three-judge court, and I don't know, I just don't know why that helps anything. If the idea is just to move things along faster, just start in the Court of Appeals, but I would just start with the regular Court of Appeals panel then, and not the three-judge district court panel. I do think, though, one-judge districts seemed like a bit of a problem. There's not that many single-judge, they're not districts, they're venues, courthouses. That seems like a bit of a problem in an APA case. It didn't necessarily have to be, but it turns out it is. And the proposal, it could easily be fixed. Lisa mentioned that there was a suggestion that that basically the Texas stopped doing that, and Texas said no. So that seems like that might be a good thing to fix, even just looked at objectively. We would still, though, looked at non-objectively, wind up with an appeal to the Fifth Circuit, and so we'd sort of wind up in the same place. But if you're concerned about just the sort of the structure of it as opposed to just being outcome-oriented, I think that's something that could and would be easy to fix. At one time, I thought it would be better if the case, if challenges to agency action were all sent to DC instead of some of them. Not that DC has always been our friend. There were many years when my office tried to file elsewhere. We went to the Second Circuit a few times because DC was not a good place to be bringing your APA cases. But overall, that might be better because DC does, because of the way the judges are chosen for the DC Circuit, then they tend to be less of an overwhelmingly partisan group one way or another. They tend to be more moderate. So I think those are my thoughts on some of the thoughts about how we might or might not ever get out of this situation. Oh, term limits for Supreme Court justice. That is actually the only apolitical, principled solution. The problem is it would not actually have an impact for years, but once it did, it seems to me like fair and not partisan, but doesn't seem like that's going to happen. Okay.
This was mid-level reforms was the question.
So start over?
Maybe we need
No,
big
you
ones.
got it.
Sam, do you want to jump in? Anything?
I want to be really, because Allison has analyzed these things in a lot of, she's hit all the points I would have hit. I will just generalize it. These reforms would allow, would avoid the ability of people to target these single judge courthouses, and this inures to the benefit of deregulatory folks because these single judge courthouses are in rural areas. These are not in big cities. And so if you can pick your judge, the people who like to pick their judges are people who are picking conservative judges. Our court of choice, we have 15 offices, but the place we like to file all of our cases is the Northern District of California or the DDC. These are good courts, staffed with good people, and it's a much more random draw there than it is in the Northern District of Texas. So yeah, fixing forum shopping like that would matter. But as a side note, these things are not the sexiest issues, and I think a lot of concern about the courts comes out of rights-based stuff, and so when a right gets taken down, everybody gets marching, and this maybe isn't as sexy, but it's super, super, super important. I'll stop with that.
I have an even less sexy list.
Good. Yeah, we're in administrative law land, so
But
bring it
this
on.
is, it's not even all about administrative law.
Okay.
These are suggestions that come from a sort of set of law professors who go across the spectrum. Steve Vladeck, Josh Blackman, and Ben Johnson. I just read some articles and got charged up, right? So one of the things I think is wrong with the Supreme Court today is that it's chaotic. It used to be so sort of serene. It's not anymore. It's chaotic. The emergency docket has made things crazy. That has implications for agencies when they're in this litigation. So here are a couple of ideas. One, ditch the summer vacation for the justices. Make them meet all year round. Make their jobs year round. It's not unheard of in the United States, right? Bring more order, have them deal with cert petitions all year round, not wait for the long conference in September. Second one, the consequence for failing to act on a cert petition within 90 days should be denial of that petition. Just
Oh, I love
period,
that.
the end.
That's
Stop having all of these relists and shenanigans and rewriting the question presented and so forth. Another one, consequences for failing to act on an emergency application within 2 weeks, automatic denial. Again, none of this having cases linger, which they have on the emergency docket for a long time while they decide. Another one, this seems simple, specify the standard of review for the emergency docket, which has been strangely elusive,
That sounds
right?
like law.
Right, exactly. It's so unsexy, but it makes me just practically, I want to stand up and say this, right? Maybe, I don't know how this would be drafted, but don't let the Supreme Court rewrite the questions presented. It just seems to me that that is not a judicial function to decide what arguments will be made, right, to the court itself. And then last, and this is going to seem weird to you, but I think to some extent that the justices suffer from too little work. look at all those opinions. I read the decision on a stay application the other day. Oh my gosh, there were 3 separate opinions, I think, explaining why they agreed or didn't agree. Dissent from a footnote in one of them. This is all on the emergency docket. They have too much time. They write too much and too badly, right? So here's
You
one
want them
thing.
deciding more?
Yes. Here's what I want them to do. I want them to do their basic function, which is to harmonize the law across the United States. There are open circuit splits that last and last and last. So why not make jurisdiction mandatory over an appeal that comes up with a frank circuit split? You could have a certification or something like that. I think that's what Josh Bachman says. And maybe is entrenched, give it a year, something like that. And at that point, there's mandatory jurisdiction over the case that comes up from the circuit split. And that might mean, maybe, all of these things might mean they act a little bit more like a court.
So it's fun to sit on panels with academics because you write down some of this stuff, but then I have a question or two for you.
I think it's time for questions.
What the hell? Like, what does it mean if you say you can't rewrite the QPs? Because, parties write multiple.
Well, this is all based on an amazing article, you should all read it, by Ben Johnson about questions presented. And he goes through this
How
whole
long is the
history.
article?
It's about 8.
And
It's
is
a large
because I always
article.
feel like law professors sometimes have too much time on that.
We have just the right amount of time.
On that note,
I think they take fewer cases in part because they're writing all those opinions as opposed to maybe it's a chicken and egg, but I think it's the chicken, not the egg,
Yeah,
whatever.
but I wouldn't mind them solving some of these splits.
Oh,
doing
yeah,
what they're there for.
We had a cert petition with a clear split. The other side agreed there was a split that they denied this year. But yeah, they did each write 5 concurrence from footnote 2 on page 3 of yeah.
let me just say that the second code, for those of you waiting, is Savannah, S-A-V-A-N-N-A-H.
We were guessing Athens.
I thought Athens.
Yeah. And now it's time to open up for questions. So if you can just approach the mic, that's for recording purposes. Great. So we'll start with Peter Shing.
Thanks, and this is a great panel, but I want to make your life brighter by giving you some positives. So, and this will to some extent, well, I'll start with the one that's least general. So I was on an amicus brief that got filed this week in the Northern District of Texas to support the FTC's non-compete rule. Another amicus was filed on the same side by Matt Gaetz.
Really?
Really. So, was not on
Makes
my
you wonder
bingo
about your
card, but
position.
there it is.
That doesn't make me feel better. It makes me feel really confused.
He's
Or,
done-
or we could be living in a bizarro world. I don't know. Second thing, so if I say Schedule F, some people will already know what this means. The Trump administration at the very end tried to take out of the competitive civil service any expert policy advisor that had any impact in all the agencies and put them in the so-called accepted service so that they could basically have more control over hiring and firing. There's very broad language in the Civil Service Act that allows the president, if it's read literally, to do this. But it's unheralded. It's transformative. It's never been done before. It's clearly in violation of the major questions doctrine. And so and this remains a policy priority of Project 2025, the sort of right-wing pre-preparation for a second Trump administration. The major questions doctrine is actually the strongest doctrinal weapon against that move. And the third thing I'll say, and I just want to preface this by saying, although I'm a board member, I'm speaking only for myself, not for the board, but in response to what Lisa said, we are the resistance. I mean, the way I think of the ACS mission is that we are trying to create the human and intellectual infrastructure to put back in place a pragmatic, pro-democracy, rights-protective jurisprudence of the kind that was dominant before Reagan. That's That's what I think we're doing.
Thank you.
I'm supposed to ask a question. I think we're doing?
Thanks, Peter. We can see whether maybe Allison will take on the Schedule F case. Hopefully it will come.
There's a lot of talk about the Schedule F situation. I mean, like prep about, fighting back if it happens.
Next question.
Yeah. So hi, everybody. My name is Sean Flame. I just wanted to I'm a federal attorney, and I work in a program that was established by federal law, but we implemented a whole series of regulations so that we could actually go through and do the program. And then about 7 years ago, the Supreme Court said we have no authority to issue regulations under our housekeeping statute. So this program has actually been frozen. We would like to make improvements to it. We would like to improve the regulations, but we know that if we try to do any sort of changes at this point, that anybody who might be able to come in and kind of knock out all the regulations of the program together. So I can tell you right now, in the federal government, the timidity is already there. The fact that we cannot improve our program because we don't believe that we no longer have the authority to actually promulgate rulemaking. So that was the observation part. And so the question part is a little different. The gentleman that was just here was talking about the FTC's new rule on non-competition, I'm misphrasing it, but the particular contracts where you can't compete and whatever else. If you look at the history of the FTC Act, the FTC was created in 1915 in response to the Supreme Court basically saying the antitrust laws didn't mean what they meant anymore. And if you look at the legislative history and everything, it talks about how they created the FTC to solve major problems. So now we have a non-compete rule and a legislative history where Congress went out of its way to say the FTC is here to do major things and major big things, but we're going to run into the Supreme Court, because it's going to get there, saying, well, is this too extreme, even though Congress was absolutely clear? And I'm just wondering if anybody, kind of has a comment on that. When you have such a clear legislative history, the FTC was created to do big things, but now the Supreme Court says, well, but not that big.
I have a comment. Yesterday, the Supreme Court handed down a case involving Indian tribes, and Chief Justice wrote for the court, the Chief Justice, and he said a couple of times he referred to the purpose of the statute, right? Hold the phone. The Chief Justice referred to the purpose of the statute, and then cited the policy declaration in the statute. There's something going on. I don't know what it is, but I like it, right? There's something. It referred to the purpose of the statute. I haven't seen that in a long time, especially from the conservative side. So I'm just wondering whether there's something loosening, if that's hopeful enough.
I think it's only loosening to the extent that they need it to loosen for the ends that they have in mind. I'm just...
For the particular case.
Give me my little hope. I'm with you basically, but
right,
this
just
was
making sure.
something I really thought that was. I just thought that's not accidental.
I was thinking about this when you mentioned, maybe we should start making those arguments, the old school arguments that we never made. And the problem is, at the level of every individual case, you always want to do the best you can for your client. And for your client, you probably want to remain mum about that, since you don't want to piss off the judge. Sorry, just making sure. All right.
We're very close to time. If you can state your question really briefly, and we'll have a very brief reply, and then at that point I'll remind you that the closing plenary is in the Savannah Ballroom, located on the 10th floor, starting at 4:30. So, just very brief question.
Yeah, I'll try to be quick given the nature of my question. My name is Cole Bennett. I'm here as a recent graduate of the Georgia State College of Law, but also as a representative of an organization called Move to Amend, which coincidentally is tied into my question. We talked a lot about mid-size reforms and resistance, and I just wanted to know, as I kind of see in real time this court afford itself more and more power and become, for lack of a better phrase, maybe more and more corrupt or even openly sometimes contemptuous if you read some of these opinions, that it goes beyond the administrative state into kind of all aspects of life. At what point do we, as a legal environment, a legal and a political landscape, need to start exploring and embracing large-scale reforms, such as constitutional amendments and constitutional conventions and reworking the court? And do you think any of these are more viable than the others in terms of reforming the court and their power they're affording themselves?
It's a big
I
question.
think
of
a
our day.
constitutional convention would be chaos, and that we, as much as there's a couple amendments I'd like to get rid of, and a couple I'd like to add, I just would have no confidence we'd be at the right place at the end.
We have two countries.
The most honest
We
I
have
can
to-
be is say, I'm not sure. I'm not sure which are more promising. I do think we're at a very difficult moment. And I understand that the argument is that it would descend into chaos, that it would be uncontrollable and so forth, but I sort of do believe in trying a lot of stuff. And we are in a situation, I know these are not things that are going to be changed, but boy, oh boy, every time I think of the 2 senators from every single state, the refusal to make D.C. and Puerto Rico states, the Electoral College, every time I think about those things, I think, how can we even continue to say that we have a republic with those pieces in place? So I'm in favor of thinking about those things. I just don't have very much expertise about how probable they are.
And folks
Thank you.
are moving. When I came to Earth Justice 5 years ago, we were not. We did not talk about these things. And I'm the one that decides precisely what we say to the New York Times about these things. And I go into our board meeting in a couple weeks and I'm saying, we're going to start saying this. Everybody okay with that? Because that's what we're going to start saying. And it's much more about large-scale reform. We stayed out of that, but we're going there.
So with apologies to the other questions, and with thanks for all of you coming, and a special thanks to our absolutely fabulous panel, can you join me in thanking them?
Great. 5:45? What? Oh, you're fine. I mean, if there's a train and you won't get caught in traffic, you'll be there in half an hour, right?